That is why he was at the dentist. He did, once he found out that Oakdale was discharging him because of this, he did go to Spera. He tried to get a bed at Spera, and they did not have a bed for him there.
Yeah, you can look at the GPS coordinates, Your Honor. Spera is a safe place for me. Spera is inside the Don Farm community, which I just did all this time programming. I had no problem inside of Don Farms. The only reason I went to Oakdale, Your Honor, was to receive this housing. Don Farms is a very open treatment center, so I'm able to go out on weekends with my sponsor. My sponsor is the boss and owner of Home Solutions 101. He's given me employment. He's even helped me pay the DTE that's scheduled to turn on August 7th at Danbury. I'm not saying that what I should have done, Your Honor, is I should have called my facility the moment I found out that the appointment was at 2:30 and not 11:30. I didn't do that. And one thing Don Farm taught me was to own my part. And like I keep going back. I don't know why I didn't do that. It would have. I don't. They say I have a thinking disease, and I don't know why I didn't do that. I should have called them. The only thing I can tell you, Your Honor, is I have 120 plus days clean. I'm before you clean. And that means something to me, and I've gained a lot. I'm not asking for like a let go, but I am asking for like an alternative sentencing that doesn't expand on my homelessness. I messed up the probation you originally given me because I was homeless, and just in this short time to be 5 years homeless and to gain this significant opportunity is really huge for me. My biggest fear in this whole thing, in my thinking, is I don't want to lose this homelessness. I begged and cried on the phone for them to come pick me up. They didn't even give me a chance to show them the paperwork. They didn't give me a chance to drop for them. The wear and tear did start. I ran really fast from the school of U of M on Fletcher Street to Sparrow. Like, I mean, I'm talking, I ran really fast. I've been on tether before. I ran like a gazelle, man. I ran there trying to obtain bedding because my thought process was if I could get into rehab before the violation of tether, that I would be able to argue to you that I did the next right thing. Today I'm at your mercy. I just don't want to lose this housing, Your Honor.
So you're indicating that he's denying that he violated it in any way?
I think, I mean, I know Mr. Collison is very sure that he did not, or very strong, I guess, in the assertion that he did not tamper with the tether. And I guess the discharge from Oakdale by his representation is a miscommunication about this dentist appointment and how long it was going to be, how long he was going to be there, the necessity around the dentist appointment.
I didn't tamper with the tether. I did not try to take off the tether. If you look at the coordinates, I'm not lying.
Well, he wants a hearing on all of this then. Is that what he's telling me?
I mean, I'm asking Your Honor he's done, since he was on probation, he did 90 days in Wayne County. I know Your Honor declined to give him credit for that time. He's done time in our jail here in Washington County. He's been clean for, like you said, over 120 days. He's done almost 70 days at Don Farm and Oakdale of treatment. He has housing that he set up. He has employment through a sponsor that he has set up. I'm asking this court to relieve him of his obligations to this court and the remaining balance, given all of the good things that he has done in the last couple of months. I'm sorry?
I let him out to go to treatment.
I did 74 days of treatment. I'll finish treatment. I will. I'm not trying.
Scalera?
Your Honor, I just wanted to make the court aware. I know that Mr. Collison is no longer on probation in this case. However, I am being advised by the tether agent, so the court is aware that right after he cut a strap and the agent noticed him not tracking anymore, he called and was told that he was kicked out of treatment for a policy violation. They also indicate that they have photos of the tether of when it was installed, and it was a brand new strap, if the court would like to see those.
Well, okay, thank you. Well, I don't know if we're gonna have a hearing. I guess I'm gonna need to see him. I've been dealing with tethers, I don't know how long. I've never seen two parallel cuts or tears, I guess as you're trying to say they are, that are in the fashion that they're in.
And I've dealt with tethers not as long as Your Honor, but I
Wow, that was an age thing. Go ahead.
I do know. I mean, I think the biggest argument here, Judge, is that it didn't come off of his life. I mean, he was tracked the entire time. He didn't. If he wanted to evade tracking, he could have. I mean, people cut them off all the time, and
That's the argument to make, but go ahead.
it wasn't cut off. And he's represented to me that there was an initial, tear in it, months ago, and
Through the metal.
No, not through the metal. There was a tear in the rubber, Your Honor. I noticed it. We went on a trip to Whitmore Lake from Don Farm, where I was on a paddle
There
boat.
was a tear in it. Why didn't you go back over to community corrections and say, I need a new strap?
Honestly, the tear helped because it made it looser on my.
Yeah, on the back of your leg at your Achilles heel, right?
Well,
That's
no,
why it's cut the way it is.
no, Your Honor. It clonks on my. I have a bony ankle, and it just clonks. Your Honor, again, I had nothing. Cutting off the tether would have violated me, and that would have made me lose my housing. And my whole point and my whole day, if you look at I got discharged from Oakdale, Your Honor. On that day.
What I have heard is two. One is that these parallel cuts on the back of his tether strap, or on this tether strap, occurred by circumstances beyond your control. The other thing that I've heard is that you were discharged from Oakdale also for something involving the dentistry, and that was also beyond your control regarding the appointment. The only way I'm going to be able to resolve it is if you want a hearing on it. You're not admitting to these violations. And then I'll make a determination.
I don't think Mr. Collison wants to admit to the violation, so I think we'd ask for a
And we'll
hearing.
set a hearing.
Wait, Your Honor. Setting the hearing is gonna. If I'm gonna lose the housing, I'm gonna lose the housing. Like, what would I be admitting to? Tampering with my tether? Is that what I would admit to, Your Honor? Is that what the violation is saying, that I tampered with my tether?
Correct.
We have two. One that you tampered with the tether. And the other one being that you left treatment.
But okay. I didn't leave treatment.
Sir, I have heard everything that you and your attorney have said.
I didn't leave treatment, so.
If you want to keep talking, keep talking.
I'm just
Just don't interrupt.
okay. I'm sorry, Simpson. I'm sorry.
I'll set a hearing. I mean, that's the best I can do. You can bring me everything, and you're saying that there are reasons for all of this, then I'll hear those. But I will tell you with reference to, I don't know in reference to Oakdale, but certainly in reference to the tether, I have great skepticism in what's being told to the court. So,
If I may just explain to Mr. Collison one thing, Your Honor.
I
You're probably
anyway,
sorry, telling you
you just said those other things. Oh, no, we flipped them.
if you have that's change your mind.
Plead guilty. I mean, plead guilty, see what he does. Maybe he'll let me back to treatment.
Are you sure?
Yeah,
And I've explained to Mr. Collison that he's entitled to a hearing on the violation. I also advised him that we can call witnesses. He can tell his side of the story to the court. And I think he wants to admit to the violations.
Well, if he's telling me all of this stuff that I just sat here for the past 15, 20 minutes listening to,
have a hearing.
what?
Yeah, let's do the hearing. You're right. You're right. You're right. You're right. You're right. You're right, Your Honor. Your Honor, is there any way that I can be on house arrest to this new address during the hearing to sign the lease
House
agreement?
arrest will require a tether. We've had our problems with tethers, haven't we? I'll set a hearing in this matter, August 13th, 2025, 3 p.m. This bond will continue as denied until we get to the bond moment. Thank you.
No bond.
Court calls case, People versus Mark Reed.
That hearing had a little bit of everything. Michael Collison came before Judge Simpson with what turned into a full-blown courtroom marathon complete with tether tampering allegations, a disputed treatment discharge, and one of the most impassioned self-advocacies we've seen in a long time. The facts were messy. Probation alleged that Mr. Collison had tampered with his GPS, tethered 2 parallel cuts in the strap and that he left his treatment program at Oakdale. But Mr. Collison came ready to speak for himself, and speak he did. With striking candor, he admitted he should have contacted Oakdale when his dental appointment ran long and recognized that failing to do so cost him his spot. But he insisted repeatedly and emotionally that he never tampered with the tether and that he'd done everything in his power to stay on the right path. There were moments that felt like monologues straight from the heart, running like a gazelle. From the dentist to try and get a new treatment bed at Sparrow, pleading to not lose his Section 8 housing, even reflecting on his clean time over 120 days and how far he'd come after years of homelessness. It was raw, vulnerable, and deeply human. His defense attorney backed him up, arguing that the tether was never actually removed, that GPS tracking continued, and that the cuts weren't proof of wrongdoing, just wear and tear from long use and maybe an overambitious paddleboat trip. At Whitmore Lake, still, Judge Simpson wasn't sold. "I've dealt with tethers for a long time," he said, adding that he had great skepticism about the parallel cuts and that photos showed a brand new strap installed. The judge was firm but respectful. What made this hearing unique was the roller coaster it became in real time. One moment, Mr. Collison wanted a hearing to fight the violations. The next, he considered pleading guilty just to avoid further uncertainty. He asked about house arrest, floated the idea of alternative sentencing, and even asked if he could sign a lease while awaiting a decision. It wasn't desperation, it was someone trying to hold on to the little structure he'd built after years of instability. In the end, the court didn't rule on guilt or innocence. Instead, Judge Simpson set the matter for a full evidentiary hearing and made clear that the bond denial would continue in the meantime. And with that, the courtroom reset for August 13th. This was one of those hearings that reminds you just how complicated these situations can get, where recovery, accountability, and bureaucracy all collide in real time. Mr. Collison's story wasn't clean, but it was honest. And Judge Simpson, ever composed, gave him the space to tell it while keeping the courtroom grounded in evidence, not just emotion. Sometimes the most compelling testimony isn't about proving innocence, it's about showing who someone is and how badly they want another chance. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.